Hearing in the appeal of Indra against Casepak Limited.
Mr. Ferguson.
Yes. Good morning.
Good morning to you, Mr. Ferguson. I hope you can see us and hear us loud and clear.
Yes, I can, my lord.
And we can hear you and see you.
Thank you very much, my lord. Yes. May I begin, my lord?
Yes, please.
My lords?
Yes, please begin.
And my ladies? Yes, thank you very much. This is an appeal, my lords, my ladies, from the Eastern Caribbean Court of Appeal, and it essentially involves the interpretation of the Grenada Labor Code, the Employment Act, and the Labor Relations Act. The essence of the judgment of the Court of Appeal and the High Court is that the court has no jurisdiction to hear unfair dismissal claims, because it was not the intention of the Parliament of Grenada when they passed the Employment Act and the Labor Relations Act to make the court accessible for the hearing of unfair dismissal claims. And the matter involves essentially the Employment Act Section 82 and the Labor Relations Act Section 45(4). Just in terms of a brief background, with your leave, my lords and my ladies, Indra Williams, the appellant, was employed with the respondent for a total of 25 years, from 1989 to 2014. She was summarily dismissed on October 11th, 2014. She claimed, my ladies and my lords, she claimed to have been unfairly dismissed and immediately followed the procedures as laid down in the Employment Act, Section 82 of the Employment Act, which forms part of our bundle on page 222 of the electronic bundle. Section 82 provides the procedure when someone claims to be unfairly dismissed. And it is a three-stage process, my lords. The first stage is to the Labor Commissioner for conciliation. The appellant did so. And the Labor Commissioner made a recommendation which the appellant accepted, but the respondent rejected. Then came the next stage. If it fails at conciliation, which is the Minister of Labor for mediation. The matter went to mediation before the Minister of Labor. The Minister of Labor made a recommendation which the appellant accepted, but the employer respondent rejected. It was therefore left to the third and final stage. And that is where there is a distinction in our legislation between workers in an essential service and workers in a non-essential service. The appellant was an employee of the respondent's hotel, which falls under a non-essential service. For essential service workers, just for completeness, if the minister invites the parties to arbitration, the third and final stage, and the parties reject arbitration, the minister has the power under the Act, Section 45(4) of the Labor Relations Act, which is found at page 233 of the electronic bundle. The minister has the power to send the matter to arbitration, notwithstanding the absence of consent from the parties. And once the matter goes to arbitration, the decision is final and binding. One can only approach the court by way of appeal on points of law. Not so, my lords, my ladies, in relation to non-essential workers. The appellant falls into that category. With non-essential workers, the third and final stage, the minister invites the parties to arbitration. But the law allows the parties to decline to go to arbitration. And that is exactly what the respondent did. The appellant accepted the invitation to go to arbitration, but the respondent rejected. So in summary, the respondent rejects the recommendation of the Labor Commissioner. The respondent rejects the recommendation of the minister. And finally, the respondent declines to go to arbitration. What then is the remedy open to the appellant in those circumstances? The appellant moved the High Court, in an action for both wrongful and unfair dismissal. In essence, the wrongful dismissal claim survives and is before the court because wrongful dismissal is a right under the common law. However, the respondent moved to strike out the application for unfair dismissal on the basis that unfair dismissal is a creature of statute, and therefore the court has no jurisdiction to hear claims for unfair dismissal. The party, the appellant, appealed to the Court of Appeal, and in essence, the Court of Appeal dismissed the appeal, agreeing that in claims for unfair dismissal, the High Court has no jurisdiction. And therefore, my lords, my ladies, the appellant is before you today, asking that the decision of the Court of Appeal, and by extension the High Court, be set aside. Oh, it is important. So that's the basic factual background of this case. And if I may, with your leave, my lords, my ladies, indicate what the Court of Appeal's position was in summary, and what the appellant's position is in essence, before I refer to the particular cases that are in support of our position.
Mr. Ferguson, it may assist you if I say that we have all read with care the judgment of the judge at first instance and of the Court of Appeal.
Thank you. Thank you, Millard. What I would say, just in essence, as we understand the judgment, the Court of Appeal is saying that because that there is a gap, or at the level of the High Court, there is a lacuna, as they say in the legislation. And we understand the Court of Appeal's decision as saying that because there was no mention of the jurisdiction of the High Court in the Act, and there was a procedure laid down in the Act for unfair dismissal, that in itself amounted to an ouster of the jurisdiction of the court. Because if Parliament intended to give jurisdiction to the High Court, then Parliament would have said so. And the essence of our arguments or submission is that, yes, we agree that Parliament made no express provision in the procedure, save for Section 89(2), which we look at separately, but that once the legislation, and that's the essence of our position, that the Employment Act creates the right not to be unfairly dismissed. That's the right. And where there is a right in those circumstances, there must be a remedy. Had this been a matter concerning essential services, we would not be here. Simply because there's a final and binding procedure to address essential services. But in relation to non-essential services, given that one party, the respondent, declined to go to arbitration, then in those circumstances, as part of what is in essence statutory interpretation, where the statutory right falls short, then the common law and the Constitution kicks in. And unlike the position of the Court of Appeal, which in essence says that it is only if you have a common law right, you can exercise your right of common law access to the court. So common law access to the courts only deals with common law rights. And we say no. Whether it is a common law right or a statutory right, a party can come to the court, as in these circumstances where the appellant followed the procedure laid out by the legislation, conciliation, mediation, she followed it to the T, as it said. And where a party declines, then her common law rights and her constitutional rights would automatically kick in. And that is the right to access the court. So those are the distinctions that we make in this particular matter. And in essence, we rely on the provisions. The cases are and Lord Chancellor, 2017 UK Supreme Court, that deals with the common law right of access to justice and access to the courts. I'm sure my lords and my ladies would be very familiar with this particular decision. But I wish to refer my lords and ladies to paragraph 6 of that case. For what I would call
could you give us a reference? The reference in the electronic bundle, please, Mr. Ferguson.
At page 338.
Thank you very much.
Sorry, my lords. Yes, paragraph 6 at page 338. And that we say, my lords and my ladies, provide the philosophical backdrop to the right not to be unfairly dismissed, to the creation of employment tribunals. We do not have an employment tribunal and an employment appeals tribunal even as obtains in the United Kingdom, but the law made provisions for arbitration tribunals on a case-by-case basis. But Lord Reed at paragraph 6 states that relationships between employers and employees are generally characterized by an imbalance of economic power. Recognizing the vulnerability of employees to exploitation, discrimination, and other undesirable practices, and the social problems which can result, Parliament has long intervened in those relationships so as to confer statutory rights on employees, rather than leaving their rights to be determined by freedom of contract. In more recent times, further measures have also been adopted under legislation, giving rights in EU law. And in order, the final sentence, very important, in order for the rights conferred on employees to be effective and to achieve the social benefits which Parliament intended, they must be enforceable in practice. And I pause. It is correct, as both the High Court and the Court of Appeal stated, that unfair dismissal is a creature of statute. Parliament created the right not to be unfairly dismissed, as in contrast to wrongful dismissal, which historically has been a common law right. And we say, my lords, my ladies, if the Court of Appeal decision is to stand, what it essentially means is that all employers can simply go through the process where it concerns a non-essential service, go through the process, and at the end of the day, reject what the Labor Commissioner recommends, reject what the Minister recommends, and then simply decline to go to arbitration. And that would obviously frustrate their right, enforcement of their right not to be unfairly dismissed. That would not be an effective right under the law. So recognizing that imbalance, because the person against whom you complain about, which is the employer has unfairly dismissed me. You are putting in the hands of that employer the power not to determine the matter conclusively. And we say that could not be what Parliament intended. And in the absence of any clear provisions that says send the matter to the court on the basis of regular statutory interpretation, which involves interpreting the language and the context of the legislation, the common law rights and the constitutional rights must feature. So at paragraph 6, and we also refer in that case, quickly, my lords, to paragraph 66 at page 349. Paragraph 66 at 349. Lord, read again under the rubric, the constitutional right of access to the courts. He says here, the constitutional right of access to the courts is inherent in the rule of law. The importance of the rule of law is not always understood. And then he goes on, indications of a lack of understanding include the assumption that the administration of justice is merely a public service like any other, that courts and tribunals are providers of services to the users who appear before them, etc. And I just wish to invite my lords to go further down in that paragraph where he says that courts exist, right on to paragraph 68. I can probably skip in between and go to paragraph 68, the 4th line, beginning with the words courts exist. And it says courts exist in order to ensure that the laws made by Parliament, and the common law created by the courts themselves are applied and enforced. And the role includes ensuring that the executive branch of government carries out its functions in accordance with the law. In order for the courts to perform that role, people must, in principle, have unimpeded access to them. Without such access, laws are liable to become a dead letter. The work done by Parliament may be rendered nugatory, and the democratic election of members of Parliament may become a meaningless charade. That is why the courts do not merely provide a public service like any other. So here, Lord Reed makes it clear that the courts are not only there to enforce what is seen as the rights created under statute, but also the common law rights. And it is here, lords and my ladies, that our courts, we respectfully submit with great respect, abdicated their responsibility to enforce, apply and enforce, and recognize that common law rights exist too. We continue, my lords and my ladies, at the paragraph 72, line 5 at page 350. It begins with the words, when Parliament passes laws, those words, paragraph 52, says, when Parliament passes laws creating employment rights, like in the instant case, for example, it does not do so merely in order to confer benefits on individual employees, but because it has decided that it is in the public interest that those rights should be given effect. I will skip the next 2 sentences and invite my lords, my ladies, to the sentence that begins with equally at line 5. Equally, although it is often desirable that claims arising out of alleged breaches of employment rights should be resolved by negotiation or mediation, as I say, that is desirable, and we fully agree. Those procedures can only work fairly and properly if they are backed up by the knowledge on both sides that a fair and just system of adjudication will be available if they fail. Otherwise, the party in the stronger bargaining position will always prevail. Lord Reed could have been writing for this case because it is exactly what we are saying here. The appellant here is in the vulnerable position, the employee. The employer, she says, listen, I recognize that there is a procedure for conciliation and mediation, and it is desirable that I follow that procedure. And she followed it. But then comes where the court says, Madam, you are left alone. Too bad, because Parliament did not do their full work, so we can't help you.
But does
and that is what essentially the judgment means. And we are also saying, my lords, my ladies...
Mr. Ferguson, forgive me. Forgive me, Lady Arden has a question.
I'm sorry, if I interrupted, Mr. Ferguson. I'm listening very carefully. I just wanted to ask you this. Suppose that Parliament wanted to set up a scheme, let's say for bank customers, saying that if they have a complaint against their bank, they can go to a mediator, and the mediator can give damages, or rather make awards of compensation, which would not necessarily be recoverable in a court of law. Let's say you could get damages for inconvenience, distress, and all that sort of thing, which wouldn't otherwise be available. And Parliament wants to, the legislature wants to set that up. Does it follow from your submission that because the rights which an individual has, which are always very important, obviously, you're saying they must always be followed up with a right of access to the court. But that would prevent the legislature ever setting up a scheme like that, which didn't involve access to the courts, but involved compensation of some irrecoverable kind. Must there not be some circumstances, obviously they'd have to be justified economically, where Parliament can properly say, we're happy to set up some kind of system, but it won't be one which is going to give a legally enforceable right. There's going to be some other system for resolving the dispute that's arisen.
Yes. Yes, thank you, my lady. I understand, my lady, loud and clear. And we are, and the answer to that question is once there is a scheme that is set up that allows a fair and final determination of the issues, then Parliament can pass the requisite legislation, like was done in Surat with the Equal Opportunities Act in Trinidad and Tobago, which the court, this board, held to be constitutional. And we say, yes, certainly, Parliament can do so. But there must be a final and binding conclusion at the end of the day. So once that can be achieved, as it was achieved with the Equal Opportunities Act, under the Equal Opportunities Act in Trinidad and Tobago, and the judgment in Surat, we say yes. And the legislation, they can have the Parliament can have the appropriate words to ensure that you do not come to the court because you do not want, first of all, the court to be tied up with scores of these matters. I say scores because I'm talking in the context of Grenada, but maybe in the United Kingdom, thousands of matters in the United Kingdom, because the process is intended to be, as in the Employment Act, very cheap, very efficient, and timely. So, for example, the procedure from conciliation to mediation, we're talking 30 days. If you have to come to the court in those circumstances, it would be an expensive process.
Mr. Ferguson,
So we say,
Mr. Ferguson, forgive me.
Sorry.
Isn't the first question here whether the legislature intended to set up a scheme that allowed for final determination in cases of unfair dismissal in non-essential employment?
Sorry. Was it the intention of the legislator to...
I'll state that again. I'll try to.
Yes.
The first question to be addressed here whether the legislature intended to create a scheme that allows for final determination in cases of unfair dismissal in non-essential employment?
Right. Well, the intention, I believe that would have been the intention of the legislature to create a scheme for both essential and non-essential services. However, and that's the distinction, that could not have been achieved with respect to non-essential services simply because a party had the right to decline to go to arbitration, which is the only final and binding stage under the legislation.
I understand that. That's why I ask whether that was the intention of the legislature.
It could not have been the intention in those circumstances. It could not have been the intention. Because what then, at that stage, the hope is that, listen, all these matters would be resolved through the conciliation process, conciliation procedure. But if at that stage it cannot be resolved, it's tried, it cannot be resolved, then at that stage, parties may wish to take matters into their hands and provide for a route, ultimately, which is the court. And may I just, maybe as my Lord has raised that question, refer to the BVI legislation pre-2010, which it's under, it's at page 238 of the electronic bundle, to see how the BVI legislation, and we'll come to the case of Burrell, dealt with it. 238, and more particularly B6, section B6. B6,
yes.
And B6 is on page 245, 244, 245 of the electronic bundle. And under the BVI legislation, my lords, my ladies, you go through the Labor Commissioner conciliation, like in Grenada. Then you go to mediation, like in Grenada. But this is what B6 2A, 2A at the top of page 245.
Yes.
Says, failing to achieve voluntary adjustment or settlement. A, he, meaning the minister, has may remand, but I want to suspect it meant remit the matter back to the parties for private negotiations. And this is after conciliation and mediation. Remit the matter back to the parties for private negotiations, or resort to any machinery for resolving the issues which they have established or may establish. And this final clause, what's important, or for the pursuit of any legal action which may be available to them. The legislation actually in the BVI pre-2010, and I emphasize pre-2010, because with your leave, when I addressed the issue of Burrell and our interpretation of Burrell, and our view that the Court of Appeal went wrong in Ray George and Byron Smith, subsequent to Burrell, these words assume particular significance.
Well, Mr. Ferguson, those words are likely to be important, but as I understand it, the line of authority in the British, on appeal from the British Virgin Islands does establish that notwithstanding these words, there is no justiciable right which is enforceable in case of non-essential employment and unfair dismissal before the High Court in the British Virgin Islands. That's George, and it's Byron Smith.
Byron Smith, yes. Yes. And that is exactly so, my lords, and that is why we are before you today.
So you have to say that those decisions are wrong.
Yes, we do. And we say unequivocally that those decisions were wrong. And those decisions misconstrued and misapplied Burrell, which we say respectfully submit is the right decision. Because the Court of Appeal followed Ray George and Byron Smith, even in the instant case.
Well, Burrell was a case of wrongful dismissal, wasn't it, Mr. Ferguson?
Sorry?
Burrell was a case of wrongful dismissal.
That is what the Court of Appeal has interpreted Burrell to be. And if, well, as we are on it, with your leave, if I may be permitted to refer to the case, and it's on page 507 of the electronic bundle. My lords may wish to go there at this stage, 507. Yes, 507, Burrell. And there was a judgment of Chief Justice Flosak.
Yes.
In 1995. And he says here, repeatedly, a statute should not, and he was referring to the Employment Act, a statute should not be...
Sorry, you're reading at what page?
Sorry, my lords, at page 507 of the electronic bundle.
Oh, from the head note, yes?
Yes, from the head note. I will begin with the head note. That a statute should not be construed so as to abolish or restrict a common law right or remedy in the absence of unequivocal language or necessary implication from the statutory context indicating a legislative intention to abolish or restrict that right or remedy. Accordingly, the common law right of an employee to sue an employer for wrongful dismissal has not been abolished by the Labor Code Ordinance 1975. And he refers to the case of Picks and Branites, 1959. The procedure for conciliation following an allegation of unfair dismissal is not an essential prerequisite to an employee's right to recourse to the courts for breach of the employee's common law and statutory rights. And this is where all the courts have overlooked, despite our urging. It is not an essential prerequisite to an employee's right to recourse to the courts for breach of the employee's common law and statutory rights, in that the procedure may be waived by the employee. Further, the employer may be stopped from invoking the conciliation procedure by resorting to the court to resolve the dispute. And
this comes back, Mr. Ferguson, to my first question, which is what is the nature of the statutory rights?
David,
I see him. Thank you.
What is the nature of the statutory right? Milord, sorry, I didn't get it.
Yes, I'm afraid at the moment we can hear you but not see you, Mr. Ferguson. I'm sorry about this. There's a technical problem for a moment. We'll just see if that can be restored.
Oh, okay.
Bear with us, if you would.
Yes, I can see clearly.
Yes, you're back. Thank you very much.
Yes,
my question is, what is the nature of the statutory rights which are conferred in a case of non-essential employment? Is it the intention of the legislature that there should be resort to the High Court in those circumstances? And for my part, I'd welcome your assistance on the interpretation of the legislation as to what indications there are in the legislation that such a remedy was intended.
And I will answer it this way, and probably I can bring in, I will come back to Burrell. Section 89(2) of our Employment Act, and that is found at page 222 of the electronic bundle. Section 89(2).
Sorry, page again?
It's page, let me get the exact
yes.
page.
But it's 231, 232, yes.
It's 89(2), and it's to be found at the electronic bundle, page 232.
Yeah. Thank you.
Yes. And that falls under a different head of our submissions, which is the purposive approach to statutory construction. But as Milord has raised it now, I will take the liberty to refer Milord to it. And it says here, well, to put it in context, 89(1) says at page 231, any person alleging a violation of a provision of this Act may report the matter to the Labour Commissioner, who may institute or cause to be instituted a prosecution in order to enforce the provisions of this Act. And then it says 89(2), which is the material section. Notwithstanding the provisions of subsection 1, where not otherwise specified, any person alleging a violation of the Act may present the complaint to the court, and to the court means there to the High Court, for appropriate relief. So the legislature contemplated a role for the court. And under a separate head of our arguments, which is the purposive approach to the interpretation of legislation, we say, obviously, by inserting a section 89(2), the violation is a breach of the right not to be unfairly dismissed. And if the conciliation procedure as laid down does not achieve a result, then the complaint still lingers on, which is, I have been unfairly dismissed. And in those circumstances, we say, quite independently of the common law and the constitutional right to approach the court, we say section 89(2) of our Act contemplates a role for the court. So that is under the section 89(2) point. But I'm saying further, milords and miladies, to answer the question, even though Parliament falls short and did not even have it in their contemplation when debating and passing this Act, that common law right remains. That common law right remains. It is not at the pleasure of Parliament to give. It is a right that we received as part of our common law heritage. And the case of Bradford Noel, in relation to our local cases, discusses the receipts of the common law as part of the law of Grenada. And that is to be found at page 365.
Yes, what is the common law right, Mr. Ferguson, that you're referring to?
The common law right is the common law right to access the court.
Yes,
to access the court.
But as to that, isn't it possible that the analysis should be that the right that's been conferred is a right to have your complaint considered by an official body, the Labour Commissioner, and also by the Minister in accordance with the Act, and that it's not a right to go to court, but a right to have your claim considered by those bodies. Is that something that could be said? And if so, what would your answer be?
Well, it could be said, but then it would be to go back to the words of Lord Reid in paragraph 6 of R.V. Lord Chancellor. That would be a right of no use, because Parliament would be conferring a right. Say you ought not to be unfairly dismissed.
It may be. But if you're right that it is of no use, you would have to say the employee in a non-essential service would be no worse if Parliament never gave anything to that employee who says that he or she has been unfairly dismissed, so that there's no process at all. There's no possibility of going to the Labour Commissioner or the Minister and having one's case considered by a public officer in those ways, the Minister of the Legislature.
Yes.
But
yes.
So what you're saying is if you're right, if it's is it right to say that the employee is better off by having this right, which may not end in litigation, but by having a right to have the claim scrutinised, and if all went well, to have some kind of mediation with the employer? Better to have that.
I understand, milady, but I would respectfully disagree with respect that that ought to be the approach taken, because in our respectful view, that would go against the grain of the authorities on this issue. Because first and foremost, and if I may buttress my answer with your leave by making reference again to our common law and constitution. Grenada became an independent country in 1974, on the 7th of February 1974. And as part of our transitional provisions, we have Schedule 2 of the Constitution, and that is to be found on page 1217 of the electronic bundle. But we preserved common law rights. But not only were those rights preserved, and that is the common law right of access to the court included, common law right of access to the court. However, it went further. It went further by our section 8.8 of our Constitution, by elevating that right, that common law right, to a fundamental constitutional right. And that is recognized in the authorities that we cited, and more particularly Casepak International and the Eastern Caribbean Central Bank, the judgment of Byron CJ, as he then was, analyzing and embracing the case of Golda and the United Kingdom, which is a case from the European Court of Human Rights, that in interpreting statute, we must take into account what the common law says, which gives that right, is a fundamental right. We say going as far back as 1215 with the Magna Carta, which was received as part of our laws in Grenada. And therefore, if Parliament says, which is the right, you have a right not to be unfairly dismissed, that's an advance. That's an advance. That right cannot then be watered down. We respectfully submit by then saying the very person against whom you are complaining, which is the employer, then can or is in a position to frustrate that right.
But my lady's question, Mr. Ferguson, is directed at whether the legislature has in fact conferred a right of that kind, a substantive right of that kind, or whether it is limited to a right to invoke conciliation procedures.
No, we said it has conferred that right. And we make a distinction between the right and the procedure for achieving that particular or enforcing that particular right. The clear rights, we respectfully submit, is the right not to be unfairly dismissed. The procedure for enforcing that right, which is separate, is through conciliation, through mediation, and through possible arbitration. If it goes to arbitration, it's final and binding. However, if it does not get there, then the intention cannot be, with the greatest respect, and we make this submission with the greatest respect, that then an employer, an employee who has worked for 25 years in a particular entity and complains that she has been unfairly dismissed is suddenly left out in the cold. We say that could not be the intention, because in interpreting a statute, the court has a responsibility to look at, to give effect to that constitutional right, in this case, as contained in Section 8.8 of our Constitution, which is the right of access to the court, and Article 6, as we discussed in the case of Golda, and Minister of Home Affairs and Fisher, and our local case, Casepak, International and Eastern Caribbean Central Bank. The courts have made clear that where, first and foremost, that Section 8.8 of our Constitution embraces Article 6 of the European Convention of Human Rights, for human rights. In Golda's case, Golda says that includes Article 6, includes the right of access to the courts.
Yes, well, we've got the point, Mr. Ferguson. We've got the point about access to the court, and you've addressed my lady's question as to the nature of the content of the substantive right here. Thank you.
Thank you, my lords. And with that, lords, may I be permitted to just return to Burrell, because we see that as a very important case.
Yes.
507 of the bundle, and we would wish to refer my lords and my ladies to particular sections of that case. And in that case, if I can just quickly run through that case, I would just make reference to the relevant sections of that case. Page 509 of the electronic bundle, the second paragraph And the third sentence is about line 1, 2, 3, 4, 5, 6, or 7, counsel for the parties. In that case, counsel for the parties then agreed that as a result of the ruling, the respondent's statement of claim had to be dismissed, and that the damages which the appellants claim in their counterclaim to be recoverable for unfair or wrongful dismissal survive as the sole live issue in the action. So in other words, in that case, the issue of both wrongful dismissal and unfair dismissal were live issues in the case. But I wish to respectfully submit, my lords, because this case is often quoted as a case that deals with wrongful dismissal. And I want to respectfully disagree in that throughout the entire case, Casepak CJ made the point that you have a common law right of access to the court, and I'm praising it. You have a common law right of access to the court to enforce your right not to be unfairly dismissed, which is a statutory right, and your right not to be wrongfully dismissed, which is a common law right. And I find authority for that position, if I may, page 511 of the electronic bundle. I just run through those for what it's worth. And Casepak CJ says here, at the time of the enactment of the Labor Code, an employee had a common law right not to be wrongfully dismissed. The Labor Code did not abolish that right. The Labor Code merely supplemented that right by a statutory right not to be unfairly dismissed. And it comes a bit lower down. And he speaks of the actual phrasing provision in C55, which says every employee whose probationary period with an employer has ended shall have the right not to be unfairly dismissed by his employer, and no employer shall dismiss any such employee without just cause. So it's a clear right. And similar provisions in our Constitution, it's a clear right given. And then Casepak CJ goes on to say, the result is that an employee now has a common law right and a statutory right. The common law right is based on contract, and the statutory right is based on social policy. So that's 511. And then we go down to page 512, if I may quickly refer, my lords. Page 512.
Yes.
And the paragraph that begins with the employee also. It says here, the employee also has an auxiliary common law right of access to the courts for the purpose of vindicating and enforcing his common law and statutory rights. So Vincent didn't end at common law rights, because the right he is speaking about, and I would wish to make this point for emphasis, because I believe that may have led the Court of Appeal to confuse the issue of right of access to the court, which is a common law right and a separate common law right, with the common law right not to be unfairly dismissed, leading them to say, to conclude in very clear terms, and I will point to the specific areas of the judgment shortly, if my lords would so permit me. But the Court of Appeal essentially says, contrary to what Casepak CJ is saying in Burrell, that you can only go to the High Court to enforce a common law right. That common law right of access to the court is only peculiar to and embraces the enforcement of a common law right. FLOSAC CJ is saying clearly in Borrell, no, it's a common law right of access to the court. And therefore, you can go to enforce both your common law and statutory rights. And then, so that's page 512. May I quickly refer to page 513, where he makes, FLOSAC J makes a comparison here with the English Employment Protection Act.
Yes.
And it begins with the words, unlike the English Employment Protection Consolidation Act. Unlike the English Employment Protection Consolidation Act 1978, referred to in Lord Hailsham's dictum, the Labour Code provides no remedy by way of compensation for an employer's breach of his employee's statutory right not to be unfairly dismissed. And I just wish to pause here to make this point that the Grenada Labour Code differs from the BVI Labour Code in that regard, because our Labour Code in Section 83 of the Employment Act makes clear provision for the remedies that one should, the remedies for unfair dismissal, Section 83 of our Act. So it's unlike the BVI Labour Code. But FLOSAC J continues, the Labour Code merely provides for conciliation, which I would hesitate to classify as a remedy. And that goes back to the point raised by Lady Arden as to whether, again, conciliation could be a remedy. FLOSAC J says, I hesitate to consider that a remedy because it is simply a procedure. So you have the right not to be unfairly dismissed and a procedure for enforcing that right. But there is no critical remedy, specific remedy. And he goes on to say that Section B62A of the Labour Code anticipates the failure of conciliation, and in that event provides for the remission of the issue of unfair dismissal to the parties. And quote unquote, that is what I referred to earlier, for the pursuit of any legal action which may be available to them. And I pause again, my lords and my ladies, because that is precisely what Barrow J.A. in Ray Smith in 2006, Ray George failed to take into consideration that the very Labour Code that was being addressed in Ray George made a provision that if voluntary adjustment failed, that the parties, among the measures that can be taken, can go pursue any legal action which may be available to them. Neither Barrow and Smith, which followed Ray George, nor Ray George itself took these words into consideration in arriving at their conclusion. And
but Mr. Ferguson, the point of George and of Smith, as I read them, is that they say that there was no legal action available to them because no right was conferred by the legislation to have recourse to the court.
No, and that is where we say, we respectfully, of course, say, my lords, that that those cases were wrongly decided, and that's part of the problem, because those cases are used for that particular authority, but those cases took no account of the common law, and the common law provisions took no account or fell short, though referring to Borrell, fell short in interpreting and applying Borrell in the way we respectfully submit that Flosac CJ reasoned in that particular case.
I can see,
because
I can see, Mr. Ferguson, that suppose in the Employment Act here, there was just Section 74 and Section 73, just the bare provision saying you have a right not to be unfairly dismissed, or the employer must not unfairly dismiss employees, and this is what counts as unfair dismissal. And suppose there was nothing else in the statute that says anything about how that right is to be enforced. I think you would say, well, Parliament, in conferring that right, must have intended it to be enforced somehow, and in the absence of any kind of provision, it must have intended employees to be able to go to the court. So then if one adds onto that a statutory provision that says, if you think you've been unfairly dismissed, you must first try conciliation. But if that doesn't work, then you can use whatever legal remedies you have. And I think you're saying that that's what the situation was under the BVI legislation. It said, don't go rushing off to the court, first try and conciliate, and only if that doesn't work, then go for your court remedies. And you say that that makes sense, and that Ray George and Byron Smith are wrong in saying that in those circumstances, the conciliation is an exclusive route, and that it effectively deprives you of your right that you would have had to go to the court if there'd been nothing in the legislation about how to enforce the right. But here we have the additional factor that we not only we have the right conferred by Section 74, we have the obligation to go to conciliation and mediation first, but then we have the added point that it makes the legislation applicable here, makes it clear that the arbitration route is only for essential workers, and it can't be imposed on the employer of non-essential workers. And I think you're saying is, well, so then you come to a stop as far as conciliation and mediation is concerned after more stages, but still, if you come to a stop, you can still fall back on the right that would have been conferred on you if there'd been absolutely nothing in the legislation about how this was to be enforced. And right. I think that the question for us then is that right? Or does one read the Labour Relations Act as effectively creating an exclusive and exhaustive procedure for enforcing these rights? I think that is that where we get to with your submission.
Yes, certainly I could not put it better, lady. We say where conciliation and mediation ends, then you can go to the court. And if that right had to be taken away, that common law right had to be taken away, it ought to be taken away by the use of very clear and unambiguous terms that it is taken away in the legislation. And the fact that there was not that omission does not mean, as the Court of Appeal seemed to have reasoned it, because it is not there. That means the Parliament did not have the court in its contemplation, and therefore somehow, as the learned Justice of Appeal stated in a judgment, that Parliament has actually ousted the jurisdiction of the court. And I pause here to also make the point, my lords and my ladies, that they not only are we saying it's a simple common law right, because we are saying that common law right when we gained independence in February 1974, was elevated is the same right. It's the same right because through our savings clause, the common law still apply. But what Section 8.8 did of our Constitution is to elevate that right. Elevate that right to a constitutional right, which means now that if Parliament is to abolish that right, it's not just clear words, as if you are abolishing a simple common law right. You must go further and show that there is some legitimate aim for which you are using proportionate means by which to achieve that particular aim. And all of that, we respectfully submit, is lacking in the Employment Act. It's not even referred to. It just happens that, I suppose, whether the glass is half full or half empty, and the court, by its interpretation, says, well, listen, Parliament didn't mention that at all. And therefore, it didn't mention any role for the court. Though we say Parliament did mention a role for the court, which is in Section 89(2) of the Act. But even aside from that, they are saying, listen, no mention is made of it. But the plethora of authorities, we respectfully suggest, say, when you are interpreting statute, you take into account language, context, and underpinning all of that, unless express terms are used, are common law and constitutional rights. That we cannot just look at the bare words of the statute and say, well, this is what was Parliament's intention. And that is in essence what we're saying. And I just want to make just two more references to Burrell, where for the third or the fourth time, I think he repeated it about 5 times, on page 513, where Casepak CJ says, in those circumstances, the first question required to be decided in this appeal is whether the Labor Court unequivocally discloses a legislative intention to make the exhaustion of the procedure for conciliation a prerequisite to the employee's recourse to the courts for remedies for breach of the employee's common law and statutory rights, and thereby to restrict the employee's right of access to the courts for those remedies. So it's the same act, the same structure of that act that Casepak CJ was considering here. And even in this particular case, my lords and my ladies, unlike Burrell did not invoke the conciliation procedure at all. He just went straight to the court. That was under consideration then. In our case, the appellant invoked the conciliation and mediation procedure. She did so. So she even did more in this particular case. And my final reference, and I just make this point for emphasis, there, because at page 515, Casepak CJ again says, for the 5th time, in the light of the principles, 515 over the middle of the page.
Yes.
He says, in the light of these principles, I conclude, that's a conclusion, that the appellant's exhaustion of the procedure for conciliation prescribed by the Labor Code was not a prerequisite to the exercise by the appellants of their common law rights of access to the court for the purpose of procuring remedies for breaches of their common law rights, not to be wrongfully dismissed, and the statutory rights not to be unfairly dismissed. He said, I conclude, that was a finding in the court. And I would respectfully submit, again, when it is said, as it was said by the Court of Appeal, at several points in their judgment that Burrell is a case for of wrongful dismissal. I respectfully disagree. What the case concluded on, they pleaded in Burrell both wrongful and unfair dismissal. However, in the relief that they sought, they only sought relief for breach of contract, which the court concluded was wrongful dismissal, and therefore made the award on that basis. But throughout the thread, an underlying thread in the case of Burrell is a discussion of both the common law right not to be wrongfully dismissed and the statutory right not to be unfairly dismissed.
Mr. Ferguson, could I ask you this about Burrell? Burrell is a decision in relation to section B6(2) of the BVI legislation. Might it not be said that section B6(2)(a), I'm looking at page 510 where we see it set out in the report, which specifically contemplates that if the conciliation process does not succeed in reaching a settlement, that the matter shall be remitted to the parties for them to pursue any legal action that may be available to them, that by that language, the legislature in the BVI made it clear that it contemplated that there was an underlying legal right created by the relevant provisions of the legislation, which could be taken to the court if mediation failed. Might it not be said, contrast our case, where the only remedy specified in relation to complaints of unfair dismissal is that in section 82, or the only procedure for securing a remedy, which is the three-stage process that you've outlined to us, but that by the language of section 82(5), where it talks about the matter may be referred to the arbitration tribunal, that is clearly intended to cross-refer to the regime in section 45 of the Labour Relations Act, where sometimes an arbitration tribunal may be agreed by the parties, sometimes it may be imposed on the parties if one's dealing with essential work, but sometimes there won't be an arbitration tribunal, in which case the what might be said to be the exclusive remedy specified in the Grenadan legislation has simply been exhausted when one gets to the end of section 82. So to summarise, might it not be said that the BVI legislation contemplates that there are underlying rights, the relevant statutory provisions create underlying rights which can be enforced in the court, whereas the Grenadan legislation does not do that and contemplates that the only relevant procedure is that in section 82?
Yes, and if I may answer it this way, Millards, we say, in fact, that the Grenada legislation goes even further than the BVI legislation, because in our legislation, it sets out in section 83 all the remedies for unfair dismissal. It actually sets it up, including compensation, including re-employment, re-engagement. It's set out in section 83(1).
But Mr. Ferguson, I'm so sorry to interrupt, but I feel that I have to pick you up on that. Section 83(1) specifically says if the arbitration tribunal...
Yes, sorry, Millard, I meant 1. I didn't mean section 83(1). Sorry, I meant section 83. Let me just pull it up. And sorry, Millard, because sometimes I'm seeing the court from a distance, so I can see the images, but sometimes I'm not making out, I can't make out specifically actually who is speaking at times. So,
all right. Mr. Ferguson, this is Lord Sales making this point. If one looks at section 83, I think all the provisions in it are predicated on what an arbitration tribunal shall do. But that presupposes that one has actually managed to get to an arbitration tribunal. Section 83 does not say what a court should do.
No, and that is correct. It says what the Section 83 speaks about remedies, and it's remedies that an arbitration tribunal can award if it gets there. So that's one. I was referring to the Grenada legislation going even further than the BVI legislation. Yes, thank you. I can see, yes.
So what remedies do you say the court could grant if there is a right to go to court?
We say with respect, Millards, that the court, in those instances where the legislation can grant the remedies under Section 83, we say the court can grant similar, if the matter goes to court and is not settled at the mediation stage, then the court can grant the same remedies. And certainly a compensation for unfair dismissal. But we say that the court can grant the same remedies.
And where do we find any support for that in the legislation?
Yeah, well, the court in itself, we do not find support in the legislation itself, because the legislation, well, let me put it this way. May I refer to Section 89.2 in that context? 89.2. 89.2 says appropriate relief. The minister may, after consultation with the labor, 89.2, notwithstanding the provisions of subsection 1, where not otherwise specified, any person alleging a violation of this act may present the complaint to the court for appropriate relief. And we say that this has its parallel in B6 of the BVI Labor Code, expressed differently, but it has the same effect. Because when one declines to go to, when the employer declines to go to arbitration, then the employee can exercise his or her common law or constitutional right to go to the court. And what 89 says, 89 does not restrict the court. 89 does not restrict the court in any way in terms of the actual relief that the court can award. It says appropriate relief. And we say that appropriate relief can embrace the relief set out in Section 83 of the Act.
Thank you.
Much obliged, Millards. And may I, with your leave, Millards, look at the case of Ray George, which is a relatively short case, and is found in our electronic bundle at page 491. 491 of the electronic bundle.
Yes.
Yes. And I just wish to point out in Ray George that, like Burrell, Ray George did not invoke the conciliation procedure. He went straight to court. He went straight to court in this matter. And the reasoning, we turn to the reasoning of the Barrow J.A. And it says at page 495 of the electronic bundle, 495, paragraph 15. May I invite the court to paragraph 15. Page 495. And this is what Barrow J.A. said in discussing Burrell. In Burrell versus Schneider, he said, but it's Trader. So Vincent Closack CJ explained that as a result of the provisions in the labor code, there were now two regimes governing employment relationships, and an employee was entitled to different rights under them. He said, quote, at the time of the enactment of the labor code, an employee had a common law right not to be wrongfully dismissed. The labor code did not abolish that right. The labor code merely supplemented that right by a statutory right not to be dismissed. It says the common law right is based on contract and the statutory right is based on social policy. The provisions of section C57 and C58 of the labor code ensure that the two rights harmoniously exist. And then the learned judge goes on at paragraph 16. Thus, dismissal may be in accordance with the terms of a contract of employment and nonetheless unfair. In this case, as I have said, the respondent conceded that the appellant was unfairly dismissed. So there was actually a concession that the appellant was unfairly dismissed. The master ruled that the appellant was obliged to invoke the conciliation procedure for unfair dismissal that the court provided before the appellant could proceed at law with his complaint of unfair dismissal, as a ruling in the court below. The appellant contends that he was not bound to follow that procedure, but was at liberty at once to seek an award of damages in the courts. On the other hand, the respondent contends that the conciliation procedure under the code is the sole recourse available to the appellant. And it goes on, Barrow J, citing Burrell and Closack CJ, says Closack CJ decided the very question, what is the remedy of an employee for unfair dismissal? And he quotes it here. Unlike the English Employment Protection Consolidation Act 1978, the Labor Code provides no remedy by way of compensation for an employer's breach of his employee's statutory right not to be unfairly dismissed. The Labor Code merely provides for conciliation, which I would hardly, and that is Sir Vincent saying I would hesitate to classify as a remedy. That is merely a procedure. Section B62A of the Labor Code anticipates the failure of conciliation, and in that event provides for the remission of the issue of unfair dismissal to the parties for the pursuit, and Barrow J.A. actually cites it, for the pursuit of any legal action which may be available to them. It seems to me that that decision definitively, says Barrow J.A., answers the questions raised by and exhausts the present appeal. Unlike under the Labor Code, conciliation is the only remedy for unfair dismissal. But that is not what Closack CJ was saying. In fact, the judge quoted it. Closack CJ said, I would hardly classify that as a remedy. And though Barrow J.A. cited that the B62A of the Labor Code of the BVI, where voluntary adjustment, you may remit the matter to the parties for the pursuit of any legal action which may be available to them. And I pause here to say, Closack CJ said clearly in that you don't even need to exhaust the procedure. Because unless Parliament oaths in very clear and unequivocal terms the common law right of access to the court, Casepak CJ was saying you can proceed. Because in this case, there is a procedure, but there is no remedy. Because there was no equivalent of Section 83 of the Grenada legislation, which provides remedies. So Casepak CJ says, no problem using the conciliation process. May or may not be resolved. Of course, if it is resolved, there is no need to come to court. But certainly if it's not resolved, or if you feel to bypass it, you can come because there is the common law right of access to the court. And then now, Barrow J.A. went straight to his conclusion. He says, the respondent cross-appeal the master's order directing that the claim for unfair dismissal should proceed. And in that case too, the master did it on the basis, well, though it does not say here, but by implication, she may have stayed those proceedings to allow the conciliation procedure to take place. But she did not dismiss it. And ROJA goes on to say that the decision of Casepak CJ clearly confirms that the respondent is right in arguing that unfair dismissal does not give any separate cause of action for damages or any other remedy. With respect, my lords, and I respectfully invite a reading of both cases that we just went through. Barrow Casepak CJ did not come to any such conclusion. The essence of his conclusion, where he said, I conclude, is that parties have a common law right of access to the courts, and you can enforce it whether one, it's a common law right not to be unfairly dismissed, or whether two, it's a statutory, a common law right not to be wrongfully dismissed, sorry, or a statutory right not to be unfairly dismissed. And then he goes on to say, the master therefore ordered in directing that the claim for unfair dismissal should continue. I would therefore allow the cross appeal. So that is the sum total. In this case, or in the extracts from Borrell by Casepak CJ, no mention is made in this case of the save and except to say that under the Labor Code, there was a right not to be unfairly dismissed. Barrow J.A. did not go on to embrace the main conclusion of Casepak CJ, which was that you have that right of access to the court, whether it's common law, enforcing a common law right, or a statutory right. Had he done so, we respectfully submit, he would have come to a different conclusion in Ray George. I turn now, my lords, with your leave, to the case of Byron Smith, which then followed Ray George. And then everybody else from 2006 up to now follows Ray George and Byron Smith.
Well, in fact, George and Smith were reversed by an amendment in legislation, weren't they, in 2010 in the British Virgin Islands?
Yes, in the British Virgin Islands. That is so, because at that time the court said that you have no right of access to the court. And I must mention, as Millard has raised that point, that in the St. Vincent legislation, arbitration is final and binding. There is no distinction. In the and we have included that in the package, the St. Vincent and the Grenadines Protection of Employment Act, to be found at page 307. I would merely mention it. And also in the Barbados Employment Rights Act, you don't need to go to the court because you have a final and binding procedure which results in a remedy. So in all of these instances, you have a right, which is the right not to be unfairly dismissed. You have a procedure to enforce that right. And then you have a remedy at the end of the day. Have I or have I not been unfairly dismissed? If I am unfairly dismissed, this is what I'm entitled to. So there's no need to go to the court. And we say so that Ray George was wrong on two counts. One, though Barrow J.A. mentioned it in his citing of FLOSAC CJ, that the parties can go to the court for the pursuit of any legal action which may be available to them. Though it's mentioned, he never applied it to the case in that judgment. Or it can be argued because in Ray George, there was no exhaustion of the procedure, which FLOSAC J said you didn't have to do, because there was no exhaustion of the procedure, which is the position that the master took. Exhaust the procedure first and then come to court. Barrow J.A. says, listen, the only remedy you have is the procedure itself. You recognize the right, but he conflated procedure and remedy as being one and the same. And in Byron Smith, in that case, to distinguish it from Byron Smith, from Ray George, sorry, Byron Smith claims to have been unfairly dismissed. And if I may refer to page 499 of that judgment, page 499, he alleged that the corporation, paragraph 2, Mr. Smith was employed by the British Virgin Islands Electricity Corporation. By letter dated 20th June 2001, he was summarily dismissed for insubordination. He alleged that the corporation dismissed him because he failed to accept an offer to be transferred from the island where he was employed at the time he entered into his contract of employment to another island in the British Virgin Islands on terms and conditions which were unsatisfactory to him. And then now, pursuant to the provisions of the Labor Code, he invoked the assistance of the Labor Commissioner and the responsible minister, but to no avail. So unlike Ray George, Byron Smith went through and exhausted, we dare say, the conciliation procedure. That did not result in a final decision, so he then approached the court. And may I refer the court just quickly, page 501, the decision in Ray George, because the court discussed Ray George. It says, in Ray George, the appellant claimed damages for breach of contract and or damages for unfair dismissal. And then overleaf, it cites at paragraph 11, FLOSAC CJ, and then she says at 12, to sum up, Ray George decided that the only remedy available to an employee who has been fairly dismissed is conciliation. In other words, conflating procedure and remedy. That's the procedure. But here, Byron Smith is saying Ray George decided that the only remedy available to an employee is conciliation. Learned Queen's Counsel for Mr. Smith argued, among other things, that since the Court of Appeal in Ray George did not follow its previous own decision in Burrell, so Richard Cheltenham, distinguished Queen's Counsel from Barbados, recognized that in this case. that Ray George did not follow its previous decision in Burrell. The decision in Ray George is erroneous. And then she goes on to look at Burrell, which I don't think there's any need to go through based on what we have done so far. And then at page 504, may I take the court's attention to paragraph 17, the argument of Learned Queen's Counsel Sir Richard Cheltenham. Learned Queen's Counsel Sir Richard argued that the decisions in Ray George and Burrell are in conflict on the question of whether Mr. Smith could be denied redress for unfair dismissal in the High Court, because the only procedure available to him is conciliation under the provisions of the Labor Code, which Burrell says is hardly a remedy. He then submitted that Burrell left the option open to the employee to pursue the right of access to the High Court, to seek redress for contravention of the right not to be unfairly dismissed, which he argued may not in law be hindered or impeded unless by clear and unambiguous statutory provisions. And he relied on a plethora of authorities as shown in the bottom of the page. Exactly what we argue. We say that unless that Burrell did not say what Ray George said it said, basically, that Barrow CJ did not take into account the clear edict of FLOSAC CJ that you have a right to access the court for breach of your statutory rights. And then it goes on, and I would just take the, they then quote the Privy Council case of Surat, which I would wish to point out. So Richard contended, and that deals with right of access to the court. Richard contended that the decision of the learned master in this case and the Court of Appeal decision in Ray George contravened his client's right of access to the High Court. He did, however, acknowledge that the right of access can be prescribed by clear statutory provision. And we agree with that, save and except in Grenada, it's elevated to a constitutional right, and therefore it must pursue a legitimate aim with proportionate means. He says, in my judgment, and that's page 505 continuing, the decision in Ray George...
You're reading from which page, Mr. Ferguson? Sorry. You're reading from 505?
Yes, 505, thank you.
Paragraph?
It's the last paragraph,
yes, 22. Got it, thanks.
Sorry. Yes, under right of access to the High Court. Yes. And so it deals with the argument of Sir Richard as a right of access. And then it goes on to say, in my judgment, the decision in Ray George does not contravene a subject's right of access to the court, but gives credence to the legislative intention to restrict such access. As the judge is saying, even though there are no clear words, or by plain implication, as in the case of Baraclough, where you can either do it picks and granite, by clear words, or as Baraclough states, by plain implication. She says, in fact, the decision is in concordance with the Privy Council case of Kenneth Surratt versus Attorney General of Trinidad and Tobago, where the board found, in relation to certain new rights created by statute, and quoting, this is Baroness Hale, the decision could not have been taken to increase the jurisdiction of the High Court to deal with these claims, but for the very understandable and sensible reasons. It was thought that a new and specialist body would be preferable. This is definitely not part of the jurisdiction that is characteristic of a Supreme Court. The subject matter, as already mentioned, was not traditionally the subject of adjudication at all. And she goes on to conclude, the learned judge here, that the court cannot disregard the legislative intention whether or not the new procedures appear to be inadequate or unnecessary. In other words, the court takes a hands-off approach. Too bad if your right is unfairly dismissed and you can't enforce it. We can't do anything about it because it's for Parliament to fix it. She says, in Surat, protections were not put in place to guarantee the independence of the adjudicators from the executive and legislature. And then she goes on to cite banks and executive airlines. But I think it would be an appropriate point, Millards, because this case of Surat is constantly used, as was used by the Court of Appeal in our case, to say, well, listen, Parliament can set up an alternative structure. The point I think Lady Arden made earlier, and it has a right to do so. And we say, yes, we agree with that. In fact, our position, we agree with the decision in Surat. It does not go against what we are saying. And if I can just respectfully refer to Surat at page 426. 426 of the bundle. Is at 426. It begins at 426, but we would wish to refer the court to paragraph 42 of that judgment. Paragraph 42, it's found on page 436 of the electronic bundle. Citing Lady Hale for its full force and effect. And in that case, incidentally, it's the state that argued that the the Equal Opportunities Act was unconstitutional. And the appellant was arguing that I have filed a complaint and my complaint is not being heard. I want my complaint to be heard. And the state is saying, but no, the Equal Opportunities Tribunal is unconstitutional and we need to complete the setting up. And at paragraph 42, Lady Baroness Hale says, in considering these questions, as with most constitutional questions, there is a balance to be struck. On the one hand, security of tenure, and maybe I can skip that part to go on, beginning with the words on the other hand. 1, 2, 3, 4, 5 lines down, my lots. On the other hand, the demands upon the legal system are increasing all the time and cannot be met by judges of the High Court. And we can't agree more. It is not just that the volume of traditional areas of work has grown. No legal system can stay set in stone as it always has been. It has to move to develop with the times. The complexity of the modern world was seen as the emergence of new problems which need new solutions. In the United Kingdom, for example, specialist jurisdictions have been set up to cater not only for the myriad of disputes which may arise between citizen and state, but also for some disputes between private persons. The most important examples are disputes between employer and employee and between landlord and tenant, where a different way of doing justice is thought necessary because of the perceived imbalance in power and resources between the parties. Paragraph 6, Lord Reed, R.V. Lord Chancellor. The same sentiments repeated. And said it is common for such jurisdictions to include people who are not lawyers, etc. But we wish in particular to commend to this court the words here, where a different way of doing justice is thought necessary. Under the Equal Opportunities Act, that tribunal could come to a final and binding decision. A complaint is made, so well, notwithstanding whatever may be the constitutional issues or defects, the fact is, and that is what Baroness Hale was alluding to as we understand it, that you need to set up, because the courts alone cannot absorb all of these matters. So you need to set up tribunals, in particular relating to employer and employee. But what she emphasizes here, where a different way of doing justice is thought necessary. So in other words, you create a right, but you don't clog up the court and say, well, the court is the structure to deal with these rights. For example, it may not have been an arbitration tribunal in Antigua. For example, there's an industrial court. There's an actual court set up in Trinidad. There's an industrial court. In the UK, there is an employment tribunal. All these permanent specialist bodies. In Grenada, it's on a case-by-case basis sent to an arbitration tribunal. So the arbitration tribunal is constituted differently on a case-by-case basis. But the important thing is a different way of doing justice. Can it be, Millards, where an employee who has served an entity for 25 years and she is then summarily dismissed, and we have an act which says an employee has a right not to be unfairly dismissed? Can it be said, in all fairness, that justice is done when that employee follows the procedures? Step 1, conciliation, Labor Commissioner. Step 2, mediation, Minister. And the same.
Mr. Ferguson, I think we're familiar with the procedure, and I don't think we're being assisted at the moment by your repetition of the particular facts of this case, as you maintain.
But can I ask, going on from that, presumably you would have to accept, I think, that if in this case or a different case, the Labour Commissioner and the Minister had decided that the employee had not been unfairly dismissed, that the dismissal had been justified, would you say that having then failed to get redress through that method, he or she still is entitled to go to the High Court and bring an action for unfair dismissal?
Yes, my lady. Because unless she claims she has a right, and our argument is that our submission is that once she complains that she has a right, and once the legislation or the Act of Parliament does not host that right, then she has a right to go to the court. Because she can say, for example, just as the employer said, she could have rejected the recommendation of the Labour Commissioner. She could have rejected the recommendation of the Minister, and both could have agreed still to go to arbitration. But we say she still could have come to the court. It does not change. Those factual circumstances does not change her right to appear to move the court under the common law, and the Constitution, the common law right, which has been elevated to a constitutional right.
But do you say that she does have here to exhaust the procedure under 82, Or do you say she could go straight to the High Court without asking the Labour Commissioner?
We say on the authority of Burrell, it seems to suggest that she can go straight to the court, notwithstanding that a procedure has been set out, because Burrell says that procedure is not a prerequisite for enforcing your rights. In this case, we will say, we will respectfully submit that even though she can do that in the absence of clear and express terms that oust her rights to access the court, it will be desirable to pursue the conciliation procedure. And in this case, she actually did so. But theoretically, even if she did not do so, based on the authorities, and we say, again, Aaron Lord Chancellor and Capital Bank and ECCB, on the application, your right to access the court, which exists unless ousted by clear terms. In the absence of such clear terms, in the Employment Act, she can access the court.
So could an employee in an essential service go straight to court?
No.
Because?
Because there is a final and binding procedure. There is a procedure that leads to a final and binding remedy, which they can challenge on a point of law and actually go to court. After that, if the Arbitration Tribunal makes an award and a party wishes to challenge it on a point of law, then in those circumstances they can go to court.
So that's the sole role of the court. For the essential employee, that's the sole role of the court. It's limited.
Sorry,
for an essential employee, the sole role of the court is in relation to points of law or enforcement. Is that right? In relation to the arbitration?
Yes. Yes, my lord.
And that remains so even if the minister declined to order arbitration?
The minister in an essential service must do so. Once under Section 82, once it's an essential service, and again we say because of the nature of an essential service, it's essential and therefore that service cannot be out for any appreciable time, unlike a non-essential service. So in a non-essential service, if you wish to go to court, you have all the time in the world to do so. In an essential service, there is no such luxury. And therefore, it is structured, the act is structured to say where there is an essential service, the minister must refer it to arbitration, because if he does not, then the dispute may simply, will simply continue. It will remain.
So section 45(3)(b) says the minister may decide to establish an arbitration tribunal.
233? Yes.
Section 45(3)(b).
Yes. Yes, 45. Get in the exact section. Uh, 45(3). Yes.
3B.
Page 237.
It says if there is a trade dispute in respect of an essential service and parties fail to comply with subsection 2, then it says the minister shall first seek the consent of the parties to the dispute for referral of the dispute within a time specified by him to an arbitration tribunal and for its composition and terms of reference. But if the consent of the parties cannot be obtained within the time specified, the minister may decide to establish an arbitration tribunal and determine its composition and terms of reference in his own discretion. What that does, in our respectful view, is that even though the words the minister may decide, of course, there's a duty to have the dispute resolved as quickly as possible in an essential service. And the may decide would only be in the context of if the dispute is resolved by some other means and there is no need to go to an arbitration tribunal, then the minister then may not refer it. But I think it respectfully, my lords, it follows that once the dispute continues and it's an essential services, health, police, water, electricity, then the Act gives the minister that power to refer it. And we say the difference here contemplated with the essential service and non-essential service is that time is of the essence. It is not so much of the essence when it comes to an essential service. And there is the measure of judicial review available to the parties in the event that a minister is mandated to do something under the Act which he refuses or omits to do for whatever reason otherwise.
If an employee does not have a right to have an arbitration tribunal set up or a remedy in the court, would the employee be able to bring a claim based on the obligations of mutual trust and confidence which are owed while a person is still an employee? To say you dismissed me in a manner which breached that obligation. This sort of
the answer to that question is yes, my lady.
Because in this sort of case there is allegations which I assume the appellant resists, that she had not performed properly. But let's assume that she was challenging those, and she had these allegations made against her, which she could show was wrong. I just wondered whether that was within the experience of the courts in Grenada, as to relying on the common law remedies there.
Yes, I'm not aware of one being taken on that basis, but certainly the answer to the question would be yes.
The same common law.
Be able to pursue that remedy.
Assuming it exists. I mean, if that were good in law, not expressing a view, but I just wanted to know what the scope was.
Yes, but that would be a common law right.
Yes, absolutely, not a statutory right.
Yes. We are saying, may I continue, Millards?
Yes. We're keeping an eye on the clock, Mr. Ferguson, because we have to complete the hearing within the time allowed.
Yes. Okay. Thank you, Millards. I'm guided. If I may, at this stage, refer quickly, Millards, to the actual decision of the court of the Court of Appeal.
Yes.
In and that is to be found at page
56.
56. Thank you, Mother. And we wish to refer, first of all, to paragraph 16. 16, and just let me get, may I just crave my Lord's indulgence? Yes. It's electronic one. Yes, paragraph 16, where the learned judge states, captures our arguments. Learned counsel, Mr. Ferguson, said that the judge was wrong to hold that the High Court lacked jurisdiction to hear Ms. Williams's claim for unfair dismissal. He accepted that unfair dismissal was created by statute as distinct from the common law cause of wrongful dismissal. He argued that since Ms. Williams had a common law right of access to the court, this meant Ms. Williams was entitled to approach the High Court in order to seek redress for alleged unfair dismissal. So that correctly captures what our actual argument was before the court. And at paragraph 18, overleaf, Counsel Mr. Ferguson said that the common law right of access to the court could only be curtailed by an express statutory provision to that effect, and that there was no statutory provision which prohibited her from doing so, even though it was statute that created the remedy for unfair dismissal. So that captured it. And now, if I may then quickly refer the court to paragraph 33 of the judgment, paragraph 33 of the judgment. There, where the court begins to treat the matter, not in the context of the common law right of access to the court, but to treat the matter as some separation of powers, the role of Parliament and the judiciary. And there, the learned judge says, I have no doubt that the legislative scheme of the Labor Relations Act and the Employment Act must be read together in order to determine whether there is any basis for the court reading into the statute the right to approach the High Court in circumstances of non-essential services and where the dispute resolution mechanism of conciliation has been exhausted. The question, therefore, which has to be answered is whether Ms. Williams, having exhausted the procedure that was provided by the statute, it is open to this court to seize jurisdiction in the absence of any statutory provision which provides for access to the court. Right. So there it is that the learned judge is saying that the court has to read into the statute. And we are not asking, save for the very limited issue on the purposive approach to statutory construction that our submissions cover. But we are saying you don't have to read into it because it's there. The common law right and the constitutional right underlies or underpins the act. And therefore it is there. It has to be removed. Not placed there, it has to be removed. So we are not asking the court to read into the statute. And therefore, the learned Justice of Appeal used the word that we are asking the court to seize jurisdiction. We are saying the court has jurisdiction. We refer quickly to paragraph 34. And we say that the learned judge, but so shortly, and as at the end of the paragraph, I will treat Burrell in more detail, but suffice it to say in Burrell, the statute dealt with wrongful dismissal and clearly provided for access to the court in contradistinction to the case of Bar. So the learned judge, again, we say that the learned judge respectfully was wrong in saying, and expressly so, that Burrell has no relevance in this case because Burrell was a case of wrongful dismissal. And the learned judge describes the issue as whether or not the proceedings of conciliation that were established in the statute to prosecute a claim for wrongful dismissal had to be exhausted before bringing a claim to the court. And the court then limits its scope to simply unfair dismissal when Burrell extended it to statutory rights also. At paragraph 35, where Blendman J says the court in its wisdom has decided not to provide for access to the court in circumstances where it has created a statutory right. It is simply not open to the court to so provide, bearing in mind that unfair dismissal is exclusively a creature of statute. So we say in paragraph 35 again, and running through that judgment, the learned justice of appeal is treating omission as an ouster. It's not there, so it's out the jurisdiction of the court. While we say it's always there and it has to be ousted. We go on to paragraph 6, where again the learned judge speaks about judicial overreaching and the role of Parliament and the judiciary. And we say respectfully, and that follows in the analysis for several paragraphs, the learned judge, the role of the court is to interpret legislation. And therefore, the role of the court is not overreaching when in interpreting the legislation, it takes into account what the common law says and what the Constitution says. So in those circumstances, we are saying, unlike the position taken by the court, that we are asking the court to read words that are not there. We are asking the court to rewrite the legislation. We are asking the court to overreach. We are saying simply to apply the common law and the Constitution. And therefore, we look at paragraph 38 again, where the learned Justice of Appeal quotes Lord Simons in Magor and St. Mellon's Rural District, where she mentions at the end, if a gap is disclosed, the remedy lies in an amending act. So both the judge and the High Court says, listen, there is a lacuna in this legislation. There is a gap because for people in non-essential services, there is no final and binding remedy because the employer can simply refuse to go to arbitration. So there is a gap, there is a lacuna, and Parliament needs to fix that lacuna. We are saying there is no gap, there is no lacuna in terms of the application of the Act, because where Parliament falls short and does not go as far as, in this case, as it did for workers in an essential service, we say the court can step in simply under the common law right of access to the court and the constitutional right under section 8.8 of our Constitution. And at paragraph 39, the learned judge then goes on in that context, because she has already decided that the court has no jurisdiction. So the learned judge is saying listen, if we have no jurisdiction, we can't do what you're asking us to do. You're asking us to rewrite, but we must exercise judicial restraint, as she says in paragraph 39. Quickly again, my lords, in paragraph 40, the learned judge speaks to, she says, it cannot be said enough that the duty to enact legislation devolves upon the legislature and not the court. The interpretation of statute is within the special province and exclusive control of the judicature. A close reading of section 45.4 of the LRA reveals that the legislature intended to give exclusive jurisdiction to the Arbitration Tribunal and deliberately made no provision for access to the High Court, even in circumstances where there is a failure to arbitrate in relation to non-essential services. So, goes on, if it's not there, then it was never the intention of Parliament to include it. And at paragraph 47, we say that, paragraph 47 of the judgment, we say the error, respectfully, of the court is emphasized in that paragraph where the learned judge says, by way of emphasis, the difficulty that Ms. Williams faces is that unfair dismissal is entirely a creature of statute as distinct from the common law. Therefore, it is simply not open to her to assert that her common law right of access to the court has been abrogated or infringed anyway, since the legislature has clearly ousted, and she uses the word ousted, the jurisdiction of the court in relation to unfair dismissal, and then goes on to quote Surratt. We say it's totally opposite. What Burrell says is that statutory right, you have an right of access to the court. But in paragraph 48, we say in the right principle is expressed in paragraph 48, but wrong facts. In addition, and equally relevant are the pronouncements that were made by FLOSAC CJ in Burrell, that an employee also has an ancillary common law right of access to the courts for the purpose of ventilating and enforcing his common law and statutory rights. That's one of the few places where the learned judge actually repeats there's not only common law rights, but statutory rights. His lordship stated that where statutes which limit or extend the common law are clear, there is no reason why such statutes should be construed differently from other statutes. And she goes on to quote there. And in the interest of time, I would just refer, but I would commend all these paragraphs, which contains the reasoning. But I would just wish to end on paragraph 57. And just mention 57 and 59. The learned Justice of Appeal says, turning now in more detail to Mrs. Williams' contention that the legislature has eroded her common law right of access to the court by failing to legislate for the claim for unfair dismissal to be resolved in a court of law. He says, it is settled law that the common law right of access to the court cannot be infringed or abrogated by the legislature except by clear words to that effect. Correct. The principle is so well known that it requires no citation of authority. However, and this is where we say the learned judge fell deeply into error. However, this right of access relates either to common law rights or constitutional rights. We say that runs contrary to the learning in all the cases, including Burrell. The unsurmountable difficulty, she goes on to say, that Ms. Williams has is that unfair dismissal is not a common law right, but rather, as properly recognized by the parties, entirely a creature of statute. There is absolutely no basis for reading any common law right of access into the unfair dismissal provisions of the statute. We say the learned Justice of Appeal, with respect, was clearly wrong in coming to those conclusions. It cannot be said enough that had the legislature desired to provide for resolution of the unfair dismissal claim in the court of law, it simply would have done so. Continuing on the trajectory that if it's not there, that means that it amounts to an ouster of the jurisdiction of the court. And as we say, it was always there and it must be ousted by clear words or plain implication. And my final point on paragraph 59 is section 8.8 of the Constitution. It says, I fail to see on what basis Ms. Williams could properly contend that her right under section 8.8 of the Constitution has been infringed. Section 8.8 addresses the right to a fair trial, and it is not a provision which clothes the court with jurisdiction to hear matters. In effect, this is a short point. Section 8.8 of the Constitution, just as she said in Burrell, of Grenada, has no relevance to the appeal at bar, since it has nothing to do with the jurisdiction of the court, but rather it addresses the right to a fair trial in circumstances where jurisdiction to hear the matter exists. And we say section 8.8 must have relevance, because what section 8.8 of the Constitution simply does is to elevate a common law right of access to the court, recognized in Golda and the United Kingdom in its interpretation of Article 6 of the European Convention of Human Rights, and adopted in this court by Byron CJ in Capital Bank and ECCB. That once you have that right of access to the court, it is a right. So the learned judge is saying, unless you have a matter before the court, in other words, and then you are entitled to a fair trial. So essentially, we say Burrell has relevance, section 8.8 of the Constitution has relevance, and that a party, notwithstanding that it is a statutory right, still has that common law right protected by our Constitution to access the court. And that in sum, we commend our submissions, our full submissions to the court for consideration, and it is our urging, my lords, my ladies, that the Court of Appeal, judgment of the Court of Appeal, and by extension the High Court, be set aside, and this court find that the court has jurisdiction to hear a claim in these circumstances that relate to unfair dismissal. May it please, my lords and my ladies, unless there are questions or any issues to raise, those are our submissions.
I have a short question.
Lady Rose has a question.
Just to confirm, am I right in thinking that if, in the case of a non-essential employee, the employer does consent to the arbitration tribunal hearing the case, and the arbitration tribunal arrives at a determination, that determination is then final and binding on the employer, even though the employee is a non-essential worker?
That is so, my lady. It is final and binding. All decisions are final and binding once it gets to the arbitration tribunal.
Anything further? Thank you. Thank you, Mr. Ferguson. We're grateful to you for your submissions. The board will take time to consider what advice we will humbly tender to Her Majesty, and the court is now adjourned. Thank you very much.
Much obliged. Thank you.